Hello and welcome to the Ken Vercammen Law Office Legal Podcast. This edition we're looking at DWI cases and whether someone who's not driving a car can be found guilty of DWI. And in this case, unreported State versus Speranza, Speranza. The court found the person guilty, finding basically DWI can be asleep with the engine running. So the defendant here appeals his DWI conviction in the municipal court. The defendant's conviction stems from an incident where police responded to a report of an unconscious male in a vehicle at an intersection. The responding officer found the defendant asleep in the driver's seat of his car, which was sitting at an intersection with the engine running. The officer was unable to rouse the defendant, forcing him and other officers to drag the defendant out of his vehicle. The defendant eventually came to, telling the officers he had come from his friend's house, but did not know where he was. The parties stipulated the defendant was intoxicated when the police found him. Municipal court found that the defendant was operating his car within the meaning of the DWI statute, even though it was not moving. The defendant appealed to the trial court, which conducted a de novo in which it rejected the defendant's argument that he did not operate his car. The trial court held the defendant intended to operate his vehicle because he was sitting in the driver's seat with the engine running. On appeal to the Appellate Division, the court affirmed the defendant's conviction, ruling that a vehicle did not need to be in motion to trigger liability under the DWI statute. Instead, it was enough that the defendant had the possibility to move the vehicle by sitting in the car with the engine running. And that's State versus Speranza. For more information on DWI, visit website njlaws.com. And for representation, contact Ken Vercammen's office in Edison at 732-572-0500. Thank you.